Hello and welcome to this Fox Nation special Trump on Trial live show. I'm your host, Greg Jarrah. Thanks for being with us, everybody. And so what can we expect as this trial enters the final phase? Here now to unpack it all, federal defense attorney Ronald Chapman. Gentlemen, thank you all for being with us. Ron, what do you think? Costello, good or bad for the defense?
I think overall probably a net positive. From my understanding, and I listened to Trey Gowdy earlier, he calmed down a little bit more today. Trey was in the courtroom and certainly is the type of person who can analyze a witness quite well in all of his years of prosecution experience. But here's the thing. Defense attorneys often shy away from calling witnesses. That's something I've disagreed with. In all of the trials that I've been involved in and the acquittals that I've had, the number one thing is I put as many witnesses on the stand as I can to get the truth out. And the truth is, so much was going on around this time period, and so many people were doing things on behalf of the Trump organization that it was really hard to keep everything straight, and you couldn't necessarily understand what everybody was doing. The messiness of the Cohen-Costello situation actually cuts towards Trump in his favor because it does show that he wasn't necessarily intricately involved in all of the operations. And of course, that's reasonable doubt, and that's an acquittal.
Right. Ron, Mershon allowed Cohen to testify almost as an expert about campaign finance laws and saying, oh, yes, this violated the law. Cohen's not an expert. First of all, he was a terrible lawyer. Even basic stuff he seemed to bungle. And yet the judge allowed him to be an expert on campaign finance, but when it came time for the defense to call an esteemed expert, Bradley Smith, former chairman of the Federal Election Commission, to say, look, this is why these payments in the non-disclosure agreement doesn't qualify as a campaign contribution and therefore it violates no law. The judge really wouldn't let him say that. And so in the end, the defense didn't call Smith. They were precluded by the judge. I think it's another instance of unfairness. Do you think so?
Well, yeah, it certainly is concerning, but always a difficult decision for a judge. And let me break this down a bit. So we see this a lot in tax cases and healthcare cases where we have a very complex regulatory scheme that needs to be analyzed by a jury. Typically, juries should only hear instructions about the law from the judge. But occasionally experts are necessary to explain complex regulations. That's exactly what was necessary here. These regulations are so intricate and complex, they really require something more than just mention of the law during the jury instructions. But the judge said, I will instruct on the law. Then we expect him during the charge conference, which happened today, to actually provide some instruction on federal election law. He refused to do that just today. So that 1-2 punch really starts to look like an appealable decision. In fact, Donald Trump's best appealable decision. Jury instructions are some of the most reversed types of cases. And I think that's exactly where his defense team will go with their appeal. It does look like bias. It looks like poor decision making, and it looks reversible to me.
You know, Ron, here we are at the end of the case. The prosecution rested, the defense rested. They're arguing over jury instructions right now. A week from today, they'll be closing arguments. And guess what? We still don't know what the underlying crime is, this so-called mysterious crime. I mean, this was always a preposterous legal theory. Expired misdemeanors are elevated into a felony because the false business records were done to conceal another crime, which even to today, they have yet to identify. And today, while they were arguing jury instructions, they said, well, we want to argue various theories of different underlying crimes. How in the world can any competent, fair, objective, neutral judge allow that to happen? Isn't that an egregious violation of the defendant's Sixth Amendment right? He is entitled to specifically know the accusations against him, and yet the mysterious crime is still mysterious.
Absolutely. I couldn't agree more. And here's the strange thing. We have Alvin Bragg offer this memo early on in the prosecution, very strange move, that laid out potential theories. We then heard the opening statement, didn't really see dots connected, scattershot with respect to the theories. Then we hope that by the time we get to closing arguments and jury instructions, they've picked a theory, but no, they won't stake a claim. And we have the judge in this case rejecting the idea of a double intent requirement. We know from hearing it a bunch during this case that New York law requires that for this to be a felony, you have to show that there was intent to commit a felony in covering up these business records. Well, the judge in this case has said you only need to prove intent once, and that is intent to falsify the business records, changing the nature of the statute and allowing the jury in this case to convict potentially on what is really a misdemeanor violation. That is a huge concern, and again, a massive issue in the case. And really, Alvin Bragg's team gets to stand up and say, we believe he violated the law because we believe he violated the law, and he did that by doing something that we believe violated the law. And that's it. That's not how America should be. That's not what's in the Constitution. That's not justice. And it shows that this dog and pony show was really just to bind up a presidential candidate to prevent him from running for office.
The point I tried to make, which he repeated, is that Trump is not on trial for anything he did, but for who he is. Ron Chapman, your final thoughts.
Yeah, I think my final thoughts relate to closing this case out. Shocking that we have to wait more time than jury selection took for the closings to take place in this case, but here we are. The message is that this case needs to be about something other than Donald Trump. This case needs to be about justice. It needs to be about the political will of those folks in the prosecutor's office really trying to impact the election here. But in closing, you really need to send a strong message that convicting Donald Trump is a vote against justice in that area. It's a vote against holding, or it's a vote for holding up the courts and preventing justice from being done in the murders and robberies and rapes that might have occurred in that area. And really, it would send a strong message that this sort of lawfare, as people have been calling it lately, is tolerated and tax dollars can be used in furtherance of it. And I hope those dots are connected, because I think this jury really needs to understand that we are left with the decisions that we make here in the future. And we have to live in a society that was shaped by those decisions, and they better make good decisions, and they have the power to do that. And I think that needs to be the message that's delivered in closing.
And thank you all for watching this Fox Nation special Trump on Trial live show. We'll be back next week after closing arguments. I'm Greg Jarrett. We'll see you.